Well, friends, another day, another court order in one of the many prosecutions of Donald Trump. JudgeTanya Chutkan orders the release of the evidence that accompanies Jack Smith's mega brief. But Judge Chutkan's release order comes with a catch. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, we have yet another court order in the seemingly endless prosecutions of Donald Trump. But these prosecutions will end. If Donald Trump loses the upcoming election, these criminal cases, these prosecutions will end with convictions. If Donald Trump wins the upcoming election, these criminal cases, these prosecutions will end with corrupt dismissals. The stakes could not be higher, friends. Let's start with the new reporting regarding Judge Chutkan's latest ruling. This from the Washington Post. Headline: Judge approves releasing source documents with more Trump January 6th evidence. And that article begins, a federal judge on Thursday approved the public release of redacted source documents that helped inform Special Counsel Jack Smith's explosive 165-page legal brief, arguing that Donald Trump can still face prosecution for trying to subvert the results of the 2020 election, but gave the former president 7 days to take steps to block the disclosure. In a 2-page order, U.S. District Judge Tanya Chutkan ordered the release of a 4-part appendix with potentially significant redactions, listing the sources of quotes and information to support last week's filing, which was meant to detail how the case could go forward after the Supreme Court ruled this summer that Trump enjoyed broad immunity. That ruling forced prosecutors to return a slimmed-down indictment alleging Trump conspired to overturn the legitimate results of the 2020 election by using knowingly false claims about election fraud to obstruct the government's process for collecting, counting, and certifying the vote. The justices left it to Judge Chutkan to sort out how to move forward. In the filing unsealed last week, prosecutors painted a scathing portrait of Trump's actions after his 2020 election loss to Joe Biden, presenting scores of witnesses and a handful of co-conspirators with whom, it alleged, Trump launched a series of increasingly desperate plans to overturn the legitimate election results in 7 states that he had lost. Prosecutors maintained that Trump operated in his private capacity as a candidate, not in his official capacity as president, which the High Court ruled would be immune from criminal prosecution. Okay, friends, let's take a look at Judge Chutkan's new court order. It's very short, just a little over a page. And then let's talk about what this 7-day reprieve is all about. In the case of United States of America versus Donald Trump, defendant order. The government, the prosecutors, sought leave to file under partial seal a motion for immunity determinations and appendix. After hearing objections from defendant Trump, the court granted that request with respect to the motion, but reserved judgment with respect to the appendix, that is, the supporting evidence that was attached to the motion. Defendant has now filed an opposition objecting to unsealing any part of the appendix. As in his previous filing, he identifies no specific substantive objections to particular proposed redactions. Instead, defendant Trump maintains his objections to any further disclosures at this time for the same reasons he opposed unsealing the motion, and he requests that if the court decides to release additional information relating to the office's, special counsel's office, filing in the appendix or otherwise, that the court stay, meaning pause, that determination for a reasonable period of time so that defendant can evaluate litigation options relating to the decision. Put a pin in that, friends. We're going to come back to it. The order continues. For the same reasons set forth in its decision with respect to the motion, the court determines that the prosecutor's proposed redactions to the appendix are appropriate, and that defendants' blanket objections to further unsealing are without merit. As the court has stated previously, defendants concerned with the political consequences of these proceedings is not a cognizable legal prejudice. Accordingly, the government's motion is granted with respect to the government's proposed redacted version of the appendix to the government's motion for immunity determinations. The court will grant defendant Trump's request for a stay so that he can evaluate litigation options and hereby stays this decision for 7 days. Signed, Tanya Chutkan, United States District Judge, and the order was entered on October 10th, 2024. So friends, for the most part, Judge Chutkan's order is pretty straightforward. Jack Smith filed a 165-page brief with the narrative about Donald Trump's January 6 crimes, and he filed an appendix with a whole bunch of attachments, which we know from other court filings are grand jury transcripts and FBI 302s, write-ups of witness interviews and transcribed interviews and documents, all sorts of evidence, the evidence of Donald Trump's crimes that supports the narrative Jack Smith put in his 165-page brief. Now, the brief has already been revealed, and we've been talking about it and poring through it. It is compelling, documenting Donald Trump's crimes. But the appendix has not yet been unsealed. And Donald Trump again made baseless, frivolous objections, claiming election interference and the like. And Judge Chutkan said, yeah, I reject those, and I am ordering the appendix, all of the evidence, unsealed. But because you asked for a reasonable amount of time to consider litigative options, I'll give you 7 days. The order was signed and entered on October 10th, so on October 17th, it should become unsealed unless some higher court puts a stop to it. So that's what I want to focus on today. What are the other litigation options available to Donald Trump? Let me tell you, they are slim to none, and slim is fading fast. Why do I say that? You know, I was a prosecutor for 30 years, and I was steeped in these legal issues, including what issues are appealable and what issues are not appealable. This order ain't appealable. This is the judge just setting out a ruling on whether to enter into the public record a pleading that was filed by the prosecution. That's not an appealable issue. So what might Donald Trump's litigation options be? Really, the only one I can think of is what's called a petition for a writ of mandamus. That's a mouthful, but here's what it means. It means that if a lower court judge goes rogue and does something that literally the law does not allow. I know your mind is probably racing to Judge Aileen Cannon down in Florida, who has gone rogue, but that's going to be cleaned up by the 11th Circuit Court of Appeals when they reverse her dismissal of Donald Trump's documents obstruction of justice espionage case. But I digress. If a trial court judge just goes completely off the rails and do something that the law does not support, the law does not allow, then a litigant can petition for an extraordinary writ, an extraordinary remedy in the appeals court, a writ of mandamus, asking that the appeals court direct the lower court judge, the trial court judge, to get back on track and stop doing what the law does not allow. Petitions for writs of mandamus are rarely filed, and they are even more rarely granted by appellate courts. But that is something Donald Trump's lawyers can attempt, and I suspect they will instantly go down in flames because the D.C. Federal Circuit Court of Appeals, which sits atop the federal district court, the trial court, Judge Chutkan's court in Washington, D.C., will easily and instantly reject any petition for this extraordinary writ of mandamus that Trump's lawyers file. He can try again to get it up to the Supreme Court. I predict it will go nowhere, with the caveat that the Supreme Court is no longer an honest broker of the law. The radical right-wing 6-justice majority, because we've seen them ignore the Constitution and procedures and laws before to do a favor for Donald Trump. I still don't think they're going to take this extraordinary writ if Donald Trump's lawyers try to bubble it all the way up to the Supreme Court. But I wanted to just sort of translate from legalese into English what precisely is going on in this short order from Judge Chutkan, where she says, okay, I'll give you 7 days to explore litigation options. I think she knows full well they don't have any. They don't have any winning litigation options. You know why? You know why. Because justice matters. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.